Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we get to talk again about the pistol brace rule. Now, it's actually been a while since we talked about that. The last time we talked about it, we were talking about those who were getting injunctive relief and those who weren't. We learned that certain groups like the Firearms Policy Coalition, the Gun Owners of America, the Second Amendment Foundation had gone out there and really done a yeoman's effort on behalf of their members and actually obtained injunctive relief. And then there were others. But listen, there's been a lot more developments on it. There's been a lot more going on here. A lot of people out on the YouTubeverse actually got a jump on this story. I'm a little late to the party here. That's what happens when you have a law practice to run as well. But I think there is huge news coming out of the Fifth Circuit. Now, I think the reason that you think it's huge and the reason it really is huge might be a little bit different. So that's what we're going to try to educate you on today. But today, let's actually have some good news for once. And let's talk about how ATF's pistol brace rule just got placed on life support. Okay, so the case we're talking about yet again today, and we have talked about this case before, is Mock v. Garland. Now, this is a challenge to ATF's rule on firearms with attached stabilizing braces, better known as 2021 R-08F. We call it the pistol brace rule here on this channel. Now, as we know, once this rule went into effect, all sorts of lawsuits started flying around, and there were many organizations, groups, and plaintiffs all asking for injunctive relief. Now, originally, at the district court level, no injunctive relief was granted. However, on appeal, there was some injunctive relief granted for the members of some organizations. And we've done videos on that, and we're not going to go back and rehash that. And we've done videos on those who were a little late to the party there, and we won't rehash that either. However, okay, and this is really the important part here, is that the Fifth Circuit has now ruled in Mock v. Garland and is sending this case back to the district court level, saying that, hey, you know what? We know you denied the injunctive relief. We're going to need you to take a look at that again, because candidly, we think the plaintiffs here are going to prevail. And so where I think a lot of people are rejoicing is they think that we're going to be getting a nationwide injunction now because of this case. Is that a possibility? Yes, it's a possibility. What's the probability of it? It's pretty slim, actually, okay? But here is the really good news, is that when we go through the pleadings with you, you're going to see that the court is really telegraphing that this rule is dead on arrival, folks, okay? It is right now on life support, and it is dead on arrival. And when you consider what the United States Supreme Court has shown as far as a willingness to start reining back in this out-of-control administrative state, that we have no doubt here that the Fifth Circuit is going to rule in favor of the plaintiffs. And if this is appealed to the United States Supreme Court, we do not believe that review would be accepted, because the United States Supreme Court would likely just put a big ditto on it. Now, we're going to pick up pace here. We're going to move a little fast and furious because, candidly, we could do a 30, 40-minute video on this opinion. But ultimately, the court starts its ruling by essentially announcing where it's going to be going as follows. We reverse the denial of an injunction because plaintiffs will likely succeed on the merits of their Administrative Procedure Act APA challenge. We remand with instruction to adjudicate the remainder of the preliminary injunction factors and determine the scope of any relief. And that's just the court saying, hey, listen, we believe that there is a claim here being made by the plaintiffs that they are likely going to prevail on. And because of that, district court, you need to rethink what sort of injunction is appropriate here. Now, the court went through and kind of did a laundry list, a little bit of a historical perspective, and certainly pointed out all the different times that ATF has flip-flopped on stabilizing braces, as well as many other issues. However, and they were very akin to this, one of the other things the court pointed out was the ATF theorized that under this new definition of rifle, approximately 99% of pistols with stabilizing braces would be classified as rifles. It issued approximately 60 contemporaneous adjudications with the rule classifying various configurations of firearms with stabilizing braces as rifles. Yeah, you see, it was essentially designed to outlaw every single one of these firearms. The other thing that the court was very akin to, no explanations are included for how the ATF came to its conclusion as to each weapon and platform. The AR-type firearm with the SB Mini accessory, determined to be a braced pistol under the proposed rule, now appears to be adjudicated as an SBR under the final rule. We also cannot find a single given example of a pistol with a stabilizing brace that would constitute an NFA-exempt braced pistol. Okay, now, rather than go through page after page after page, and there is a lot to geek out here, let me try to break down where the court really came down here. First of all, the ATF was claiming that their rule was interpretive, okay? And what I mean by that is the rulemaking is just really there to help assist and interpret an actual statute. What the plaintiffs were claiming is, no. This rule is legislative in nature. That is, it is not only shifting significant forms of commerce across the United States, but it actually can criminally penalize individuals. Now, this is important because depending on what type of rulemaking is occurring here, different portions of the Administrative Procedure Act applies to how the rule has to be implemented. And this is a very important thing. The court found, and rightfully so, that this is legislative rulemaking, not interpretive rulemaking. As the court put it, as applied, the test strongly favors determining the final rule to be legislative, not interpretive. Inspecting the final rule from 10,000 feet, it has a significant implications for braced pistol owners. If the government is correct and the rule is only interpretive, then millions of Americans were committing a felony the entire time they owned a braced pistol. Okay, so now we know that the rule is a legislative rulemaking order. Why is that important? Well, as the court points out then, because the final rule is properly characterized as a legislative rule, it must follow the APA's procedural requirements for notice and comment, including providing the public with a meaningful opportunity to comment on the proposed rule. Okay, and I know some of you are like, well, yeah, but we did. We submitted hundreds of thousands of comments on behalf of gun owners everywhere about the proposed rule with the old Form 4999 worksheet and all of that. And yes, you did. There was at least 200,000+ comments to the negative side of that rule. But I want you to pay attention to a little bit more here as to what the law requires. After the required notice of proposed rulemaking is published in the Federal Register with either the terms or substance of the proposed rule or a description of the subjects and issues involved, the final rule the agency adopts must be a logical outgrowth of the rule proposed. If the logical outgrowth requirement is not satisfied, a court must set aside the agency action found to be without observance a procedure required by law. Okay, let me break it down for you. So as we recall, when they were proposing the new rule, we were all spun up about this Form 4999 and all the different criteria that they were going to have, some of which made sense, most of which did not. We then all submitted hundreds and hundreds of thousands of comments because that is the rule that we were commenting on. However, when the final rule came out, it didn't look anything like the rule that we had been commenting on. They did away with the form. They took some of those criteria, mushed them all together, threw them into the Code of Federal Regulations, and then added some other subjective things. And so as the court points out, as plaintiffs persuasively posit, the NPRM and the final rule bear little resemblance to one another. The proposed rule centered entirely on Worksheet 4999, which determined by an extensive point system whether a firearm was a rifle under the NFA. And we all recall how spun up we got about Form 4999, as the court pointed out. Unsurprisingly, the comments on the proposed rule concentrated on implementing Worksheet 4999. The worksheet was the focal point of the entire proposed rule to the extent that the ATF represented the ATF Worksheet 4999 is necessary to enforce the law consistently. Nothing in the proposed rule put the public on notice that the worksheet would be replaced with a 6-factor test based on an almost entirely subjective criteria. Nor was the public, which criticized the subjective nature of the purportedly objective criteria of Worksheet 4999 and its overbreadth, were put on notice that not only would the ATF change the criteria, but it would also make the criteria so expansive as to subject an estimated 99% of stabilizing braces on the market to enhanced regulations and increase the economic effect of the rule by over $100 million. Okay, so you follow here is they took all the criticism, theoretically, and then did an about face and wrote a whole new thing and said, okay, well, here's the rule. The problem is, especially because this is a legislative rulemaking order, we as the public get to comment on what the rule is most similarly going to look like. In here, we were all commenting on an apple and they ended up making an orange. This is exactly how the court put it. Commenters were given the proposed rule. They reacted negatively, piling in almost 217,000 comments of general dissatisfaction with the use of Worksheet 4999. Nevertheless, nowhere in the proposed rule did the ATF give notice that it was considering getting rid of the worksheet for a vaguer test. Instead, the comments sought section of the proposed rule requested only additional criteria that should be considered and comments on whether the ATF selected the most appropriate criteria. Removing all objective criteria operates a rug pull on the public. And candidly, the court points out what ATF actually should have done once all those negative comments came avalanching in, which was, if comments indicated that the method in the proposed rule was so unworkable that the entire procedure needed to be replaced, then the proper process would be to start the notice and comment process again and receive public comments on the new test. Simply put, and I know this is hard to come into simple terms, but this is how the court puts it as to what is the fatal flaw with this rule. In short, the fatal flaw is conceptual. Whereas the worksheet allowed an individual to analyze his own weapon and gave each individual an objective basis to disagree with the ATF's determination, the final rule vests the ATF with complete discretion to use a subjective balancing test to weigh 6 opaque factors on an invisible scale. And the court goes on to be further critical of some of the 6 criteria, some of which existed on 4999, others were just plucked from thin air, pulled into the Code of Federal Regulations, and now giving somewhere this scale that they can determine what's a rifle and what's a pistol. But one of the things the court pointed out was the final rule would hold citizens criminally liable for actions of others who are likely unknown, unaffiliated, and uncontrollable by the person being regulated. And that is based upon this criteria that the ATF could make a determination based upon how that product had been previously marketed, not how you used the product. Think about that. Not how you actually used it, but how it had been marketed. And so what we learn here is the rule of law called the logical outgrowth. And what the logical outgrowth rule simply is hey, listen, if you have a proposed rule and you allow the public to comment on it, then we expect the final rule to look something similar to the rule that the public got to comment on. We understand there will be some tweaks, but it's going to look relatively similar. However, when you do a complete about face, you now have published a legislative rulemaking order without actually giving the public an opportunity to comment on it, as the court put it. In conclusion, it is relatively straightforward that the final rule was not a logical outgrowth of the proposed rule, and the monumental error is prejudicial. The final rule, therefore, must be set aside as unlawful or otherwise remanded for appropriate remediation. Plaintiffs are likely to succeed on the merits and thus have carried part of their burden to obtain a preliminary injunction. The order of the district court to the contrary is reversed. Now, we're actually going to do a second video that's going to help better explain the remedies or lack thereof that may flow from this. Do we anticipate that there will be more injunctive relief that can stem from this? Yes, we do. Do we anticipate that there's going to be a nationwide injunction that comes from this? No, we don't. And I want to make that clear. And if we had more time on this video, I would show the very clear case law as cited by this court as to why nationwide injunctions are such an extreme remedy. However, the best news, and this is the good news to take from this, is that there is a very clear ruling from the Fifth Circuit that the pistol brace rule is fatally flawed. And when we do our follow-up video, you're also going to hear of one of the concurring opinions that actually finds yet another constitutional deficiency with it as well. Let us remember that the rule of law for granting injunctive relief is, number one, the parties are suffering irreparable harm. That has been established here. The second and most important one for purposes of this video is that the plaintiffs are likely to succeed on the merits. And the court has unequivocally stated here that the plaintiffs are likely to succeed on the merits. And the simple reason is because, shockingly, the ATF once again did not play by their very own rules. Listen, we're going to do a follow-up video about the remedies and the concurring opinion. You need to geek out on that as well. The case, once again, of course, is Mock v. Garland. We're going to put links for it all down below. If you have any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of us. If you don't, that information is right down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.